Generally, evidence of a criminal defendant's bad character isn't admissible at trial. But there is an exception to this general rule. What does it take to trigger that exception? The 10th Circuit addressed this question in United States v. Gilliland. A car was stolen, and a few hours later, the police found Roy Gilliland driving the car. Gilliland was charged with stealing the car. Gilliland claimed that he'd just purchased the car from someone in a bar. At trial, Gilliland called his stepson Billy Tull as a witness to corroborate this story. On direct examination, Tull testified that he saw Gilliland exchange papers with a guy in a bar to buy the car. On cross-examination, the prosecution asked Tull whether his stepfather was the kind of guy who would steal cars or forge documents. Tull answered no, testifying that Gilliland wouldn't do those things. The prosecution claimed that Tull's testimony about Gilliland's good character opened the door for the prosecution to ask Tull about Gilliland's prior criminal convictions. Gilliland objected, but the court allowed the questions. The prosecution questioned Tull about 4 times that Gilliland had been convicted of car theft or forgery. The most recent conviction had occurred 14 years earlier, and the oldest conviction had occurred 34 years earlier. Tull testified that he knew that Gilliland had been in prison at some point for something, but that he didn't know any details. Later, Gilliland's wife and Gilliland both testified about the prior convictions, trying to explain them to the jury. The jury convicted Gilliland. Gilliland appealed to the 10th Circuit.